contract of work and a contract of service is something that's not that clear cut. I think they're basic principles that one must understand, and I would urge people just to, when assessing a situation, err on the side of caution and get a contract in place. But sometimes it's not possible to do this. A contract of work, let's deal with what is a contract of work. It's, for example, let's say you employ an architect to design an alteration or a building for you. It will become a contract of work because you don't have direct control over that particular person. They're not designing they'll go to their own firm and make the design, and your supervision is actually quite minimal other than giving them directions. That needs to be contrasted with a contract of service where you would own the IP rights, and these three factors kind of generally tend to say what is a contract of service. This includes the amount of direct control you have over the work, the amount of supervision you have on the work. So in other words, and where that work is being conducted. So in other words, if you employed someone who was external, your subcontractors, not employee, came into your building, you exercised control over them, you exercised supervision over them, they pretty much were an employee but for the employee's employer relationship or contract, that would most likely fall into a contract of service. And obviously there's a grey area in between. And this type of question often comes up with companies, for example, municipalities, who often outsource work to third parties and to consultants. In most cases, they're going to be contracts of work, albeit that the municipality will pay for it. If, however, that particular person almost is seconded, or there is almost a de facto, and I hate using Latin, but a commonplace, what would be established as an employee-employee type relationship, even though it's not governed by a contract, then that will be a contract of service.